One of the most glaring yet overlooked labor issues in the state of Colorado resides within prison labor. After the Civil War in 1865, the 13th Amendment abolished slavery, except as punishment for crime, which created a loophole that enabled prison labor nationwide. In 2018, Colorado voters passed Amendment A that eliminated Colorado's exception clause, and won by a large margin, winning the support of 66% of the state voters. It is noted that the amendment doesn't say that people in prison shouldn't work, but they can't be compelled or forced to work. The passing of this amendment made Colorado the first state to ban involuntary servitude through the exception clause. The Colorado Correctional Industries, or CCI, was created in 1976 and currently operates as a prison labor division within the Colorado Department of Corrections and provides work experience and job training for incarcerated people. CCI's existence and policies are historically rooted in the exception clause of the 13th Amendment to the U.S. Constitution. The passage of the Colorado Amendment A in 2018 struck the exception for the slavery and involuntary servitude for those convicted of crimes from the state constitution. Despite recent legal reforms, incarcerated workers in Colorado still face dangerous jobs, low wages of 13 to 38 cents an hour, and exploitation. While Amendment A symbolically rejected the 13th Amendment's exception at the state level, practical changes have been limited, as lawsuits and reports continue to highlight unsafe conditions and ongoing exploitation under the CCI system.
On February 15th of 2022, a class action lawsuit was filed against the governor of Colorado, Jared Polis, claiming that Colorado is failing to comply with the 2018 constitutional amendment that banned involuntary labor in state prisons. The plaintiff of this case is Harold Mortis, represented by his legal team. Richard Lilgoros was a former plaintiff who helped file the case, but he voluntarily requested to be removed as of August 26, 2025. Mortis was incarcerated for second-degree murder and placed in the Fremont Correctional Facility in Canyon City, Colorado. He filed this case because he was forced to work in prison at the kitchen, serving food to his fellow inmates while he was sick with COVID. When he tried to get out of working, he was threatened with a loss of earned time, so he continued to work. On the other end, the defendants are Governor Jared Polis and the Colorado Department of Corrections, and its executive director, Moses Andre Stansel. Later that year, in May 2022, Polis and his legal team filed a motion to dismiss. However, this attempt to end the case early ultimately failed. In August 26th, a judge denied both the plaintiffs and defendants summary judgment, moving the case to a full trial. The case is still ongoing as of today. However, the latest news articles that have covered this case were published on October 7th. According to the Courthouse News, an American news service primarily focusing on civil litigation, a bench trial in which the judge makes the verdict instead of the jury was scheduled to run through October 17th, but no additional information on that settlement of the case has been released since then. So why does this case matter? The future of prison labor in Colorado will be heavily impacted by the decision of this case. The ruling will set a precedent for what constitutes prison privileges or the rights of incarcerated people. The ruling could also bring about positive changes in how prison labor is operated, ensuring that it is not forced labor and is indeed done out of the incarcerated person's own will. This will also help reduce the incarcerated people's mental and physical health issues aggravated by forced labor.
Colorado's violation of Amendment A has led to an ongoing practice of forced prison labor under threat of punishment and impacts incarcerated Coloradans the most, especially Black and Latino Coloradans who are disproportionately jailed and put to work. Their families and communities are also negatively impacted, with prison labor policies reinforcing cycles of poverty and deepening existing racial and economic disparities. Mortis v. Polis arose because Lilgoros and Mortis argued that the Colorado Department of Corrections is violating the letter of this law by forcing incarcerated people to work under threat of losing privileges, being placed in isolation, or adding time to their sentence. Aside from restricting punishment for not working, protections on earned time could be implemented, preventing the loss of earned time if an inmate is sick and cannot work, because currently the common punishment for not working is taking away earned time. However, one would still not earn time off sentence during their time when not working. This would not only allow incarcerated people who are sick to recover from their illness, but also to prevent other incarcerated people from getting sick, potentially to the extent that they cannot work either, leading to better health outcomes across the board. Incentivize their voluntary work by increasing their payment to acknowledge the benefits of their work. Higher productivity for incarcerated people would then allow them to afford necessities, send money to support loved ones, pay restitution and court fees, and prepare for release. Additionally, stronger regulation and oversight in prisons could be installed in order to ensure that prison rights are acknowledged and that anti-slavery laws like Amendment A are enforced at prisons so that no one is forced to work against their will. Educating incarcerated people on how to file grievances and enhancing accessibility may also serve beneficial to hearing about injustices in prison.
To achieve this stronger regulation, a two-pronged plan should be put into place. Currently, every 5 years, an advisory committee made up of law enforcement officers, 2 county commissioners, a public defender, a healthcare provider with experience in jails, and an advocate assess prisons' compliance of prison standards. So firstly, prison policies and protocols should be subjected to an additional mandatory review and approval by a panel of experts in prison ethics, including academics, researchers, lawyers, and legal advocates. Secondly, state prison ombudsmen should be hired to do regular inspections, at least annually, in addition to the current assessment of every 5 years, in order to ensure Amendment A is upheld. To achieve this, Colorado could essentially follow in the steps of Virginia, which has passed an amendment creating the Ombudsman Office to monitor the conditions of confinement, support inmate advocacy, collect and analyze data related to complaints received, issue public reports of findings, assist local governments in establishing oversight committees, and conduct inspections of facilities. Findings of violations should be responded to by increased frequency of inspections and comprehensive review of the violation by the Advisory Committee and the Ombudsman's Office. As the days pass, Mortis v. Polis is approaching its end, with important repercussions in terms of compelled labor in Colorado prisons. However, in the U.S. at large, incarcerated people are still susceptible to the exception clause, being compelled to work stripped of a constitutional freedom under the pretense of punishment.